David Gingras of Gingras Law, Superior Court for the State of California, County of San Francisco. He classifies himself as intervener and former counsel for petitioner Laura Owens, and this is in the Owens v. Marraccini, assigned to the Honorable Carolyn Gold. This is the opposition to respondent's motion to disqualify. I feel like his motion to intervene and everything that went with that was already his opposition. He could have just wrote it as that. But now this is his opposition. So it's probably the same shit, different day. Non-party / intervener and former counsel to petitioner Laura Owens, David S. Gingras, respectfully opposes respondent Michael Marraccini's motion to disqualify. The motion should be denied, and the court should sanction Mr. Marraccini's counsel, Omar Serrato, for bringing it. I think you should be sanctioned. But that is my opinion. I hope the judge actually shares it with me. Introduction. It is unfortunate this court must waste its time considering the issue of disqualification, especially on shortened time. You know what is unfortunate? Is the waste of time that you use to write these things. And it is a waste of the court's time, precious time the court has, to have to read this nonsense. He says, as explained below, the question of disqualification is both moot and objectively frivolous for multiple independent reasons. I don't agree, but let's hear what he says. First, the attorney-client relationship between the undersigned and his former client, Ms. Owens, was voluntarily terminated before Mr. Serrato filed the motion to disqualify. Thus, the issue is moot before Mr. Serrato's motion was filed, a fact which Mr. Serrato knew, but which he intentionally misrepresented to this court. But you called Omar as of lately as an attorney for Laura's behalf? Is that something that you did? Because if you did, this is the exact reason you need to be disqualified. Because you flip-flop worse than a fish out of water. Second, the motion argues a conflict of interest exists, but not a conflict between Mr. Marraccini and the undersigned, rather placing himself in the role of a virtual bar counsel. Mr. Marraccini claims a conflict exists between Ms. Owens and her now former counsel, David Gingras, for various hypothetical reasons. They're not hypothetical. They are real reasons. Like, he didn't just make up a scenario and was like, let's hypothetically say that him and his client do illegal shit. And then hypothetically, they are caught doing these things together. Would he represent her, hypothetically? That's hypothetical. You being too close to this case because of your relationship with Owens is not hypothetical. It's a fact. You being a witness to this case is not a hypothetical reason. It is a fact that you're a witness to Owens' accusations. They're not hypothetical. If Mr. Marraccini bothered to read the case cited in his brief, he would know the law is squarely against him. Mr. Marraccini lacks standing to seek disqualification based on alleged conflict between Miss Owens and her counsel. The point was explained in the Great Lakes Construction Incorporated versus Berman, the very first case Mr. Marraccini cited on page 8 of his motion under the heading Legal Standard for Disqualification of Counsel. Had Mr. Marraccini bothered to read Great Lakes, he would have instantly noticed a small problem. A standing requirement is implicit in disqualification motions. Generally, before disqualification of an attorney is proper, the complaining party must have or must have had an attorney-client relationship with that attorney. I'm not necessarily going to trust your quoting of that one line because I haven't read the case myself. But you have an attorney-client relationship with Owens. So I don't think it has to be with Marraccini. I mean, that's one situation, but like you couldn't represent, like if there was another case and you were like a public defender or something like that, and you were assigned to be Marraccini's attorney, or we'll say Clayton Eckerd's attorney, that would be considered, I guess, the standing that he's saying because he has gone against Eckerd before. So him now representing Eckerd now might be a conflict of interest. But we'll see where this argument goes, hopefully on Friday. Says Mr. Marraccini never had an attorney-client relationship or other confidential relationship with undersigned. For that reason, even if a conflict exists, which none does, Mr. Marraccini has no standing to raise this argument. Third, the motion argues disqualification is proper due to the advocate/witness rule, but the motion misstates the law and ignores the facts by failing to mention that Ms. Owens gave informed consent, which defeats, as a matter of law, any disqualification argument under Professional Conduct Rule 3.7, and that the undersigned counsel decided not to act in a dual role before the disqualification motion was filed. For these reasons, the motion to disqualify should be denied. In addition, the court should impose sanctions on Mr. Serrato for knowingly filing a frivolous pleading which was brought in bad faith for the purposes of harassment and to cause unnecessary delay. You and all your motions with this have caused unnecessary delay. Because had you just left it alone or just said, I'm not representing her, court, I do not oppose being disqualified on this case, and you left it at that, none of this would be happening. But you have a whole sideshow going on in a DVRO case, and you've made it about your feelings. One of the reasons you need to be disqualified off this case is because you make this case about you and not what's in the best interest of Laura. And you incite the harassment. Maybe not incite. Let me take that back. Not incite. You just harass people in court filings. Discussion. Mr. Marraccini's motion raises two main basis for disqualification. First, argues a current conflict of interest exists between Miss Owens and her now former counsel. Second, Mr. Marraccini invokes professional conduct Rule 3.7, the advocate witness issue, and claims it requires disqualification. Both arguments are not just wrong, they are objectively frivolous. In fact, Mr. Marraccini's motion is more than frivolous. It contains intentionally false statements by counsel. I do not believe they do because you didn't point out any lies. You pointed out what you think are lies, which are not lies. And it is clear the motion was brought solely for the purposes of harassment. Really? Well, what are you doing by including people that advocate for justice against victims of Laura's? You harass, you put them in court filings, you associate them with things that have nothing to do with each other. You retaliate because you hold grudges because people hurt your feelings. Accordingly, this court should deny the motion, impose sanctions on Mr. Marraccini's counsel, Omar Serrato, and refer him to the State Bar of California for discipline. No, you should be reported. The issue of disqualification is moot. All other problems aside, Mr. Marraccini's motion should be denied for one simple reason, because the issue is moot. This is so because the attorney-client relationship between Ms. Owens and undersigned was voluntarily terminated before the motion was filed. Are you just going to repeat the same thing over and over? The single fact eliminates any need for this court to consider other arguments, all of which are based on the generally accurate statement that courts retain discretion to disqualify an attorney witness. The problem with Mr. Marraccini's position, which he takes from cases such as Lyle v. Superior Court, is that he omitted the mandatory condition precedent to a court's authority to disqualify. Failing voluntary withdrawal by trial counsel. In such situation, a trial court is vested with broad discretion to order withdrawal. If the judge feels like you should be disqualified off this case, whether Laura agrees or not, I don't think you get a say. Because it's family court. And if it was civil court, I know in criminal court you have the right to counsel of your choice, but I don't know if you do in family court. Let's see here. Do you have a right to counsel? Yeah, no, she doesn't have a right to counsel of her choice or counsel in a family law case or civil case. So the judge can disqualify you if he feels like you are not a person that needs to be involved in this and he does not want to deal with your nonsense. Here, undersigned counsel appeared on behalf of Ms. Owens at a single brief hearing. Days later, Mr. Marraccini's counsel argued various grounds existing to terminate the undersigned's representation of Ms. Owens. After considering the issue, undersigned counsel agreed, in part, The undersigned then terminated the representation and informed Mr. Marraccini's counsel of the fact in writing. Here, undersigned counsel has not filed to voluntarily withdraw. Rather, the attorney-client relationship has already ended. Accordingly, this court cannot exercise its discretion to involuntarily terminate the attorney-client relationship because no relationship exists. Yeah, okay. Not believing that shit. B. No basis exists to disqualify due to a conflict of interest. Mr. Marraccini remaining arguments are all based on false premises, e.g. that undersigned counsel has failed to voluntarily withdraw, and that as a result, various current conflicts exist. A lawyer cannot have a current conflict with a party that that lawyer no longer represents. This means all of Mr. Marraccini's remaining arguments are purely hypothetical and theoretical. For instance, and ignoring the facts that undersigned counsel no longer represents Ms. Owens, Mr. Marraccini argues a present conflict of interest exists because in November of 2024, Mr. Marraccini filed a complaint with the State Bar of Arizona against undersigned, which arose from his representation of Ms. Owens in Arizona. In his complaint, Mr. Marraccini claimed that undersigned counsel acted unethically by, among other things, reminding Mr. Marraccini that he could face arrest and criminal prosecution if he violated the DVRO by this court. The same warning was also present on the face of this court's order. It also says in there, with the intent of disobeying the order. There was no intent to disobey the order. So you forgot to underline intent. Yeah, the intent matters. Also, if Owens was eating at the Red Lobster, I mean, granted, I know she doesn't eat, but if she was eating at the Red Lobster and Mike ended up going, like, let's say she was in Illinois. Laura was at an Illinois Red Lobster. And Mike and his wife, for some reason, were in Illinois as well. For some family reunion or something. And they decided to go to Red Lobster. And as soon as they walk in, Laura Owens is there. And then, as soon as they realize that, they leave. That would not be violating the restraining order. Because Mike would not have gone to a Red Lobster in a completely separate state from where he lives and from where Laura lives to go eat. In that scenario, he would have come in contact or seen her, not spoken to her. Just he's at the hostess station and then he sees her and he's like, oh shit, nope, can't be here. And leaves. Because he did not go to Red Lobster with the intent to violate the restraining order, he went there to eat, not knowing an ex from a different state would be in Illinois that same day. And he could prove he had no knowledge of her being in Illinois because she posted nothing. And she didn't tell anybody she was going. Like, there has to be intent there. And I just do not see where the judge is going to find intent. If he does, I think there's a problem. But that is not all you gave him, was a, hey, I'm reminding that you could face criminal prosecution if you violate this. That is not what you did. You threatened to have him arrested. You are downplaying this. Continuing on. In this Arizona bar complaint, Mr. Marraccini also accused the undersigned of acting unethically by contacting law enforcement in Arizona to report that Mr. Marraccini violated the proximity restriction of DVRO by coming closer than 300 feet away from Miss Owens in the parking lot outside the court in Phoenix. Although Mr. Marraccini was not arrested at the time, he asserts that by merely contacting law enforcement to report a suspected crime, the undersigned and acted improperly. See footnote 1. Reporting a suspected crime to law enforcement falls squarely with the right of the person protected by the First Amendment and the anti-SLAPP law. Retaliating against another person for reporting a crime is also a separate criminal offense, making it a federal crime to take any action harmful to any person for providing law enforcement officers any truthful information related to the commission or possible commission of any federal offense. Well, he didn't retaliate against you. He reported you for behavior. And if you called 3 or 4 multiple police departments to try to get somebody to come do something, you're not necessarily just reporting a suspected crime to law enforcement anymore. You are trying really hard to get somebody arrested, and because one person told you no, you're like, okay, I'll find another one. So, and you knew there wasn't a crime being committed. To be clear, Mr. Marraccini's discussion of what occurred in Arizona is incomplete, irrelevant, and highly misleading. No, I don't think it is, because it is the heart of what this DVR renewal case is about. But I think you lost the plot of this being about a DVRO renewal. It's not about you, David. It's about Laura and Mike. So it is important about his view. Among other things, as of today's date, no disciplinary charges have been filed against me against the undersigned in Arizona. No charges yet. Rather, it appears the State Bar of Arizona is still determining what, if anything, it intends to allege as a basis for discipline. To be sure, this might include some aspects of Mr. Marraccini's complaint. At this time, since no actual disciplinary charges have been filed, it's purely speculative to guess what hypothetical role Mr. Marraccini's complaint may have, if any. You are told what the complaints are. They actually send you the complaints, I believe. They do in some states, maybe not yours. So the fact that you're saying that you have no idea about any of this is interesting. And we know it doesn't have to do with your DUI, because this came out, I think the fact that they found probable cause came out before you ended up with your DUI. I wish they would hurry up and file charges. I don't know what they're waiting on, but disciplinary charges. Okay. But thankfully, it is not necessary. for this court to delve into the thorny question of whether Mr. Marraccini's complaint to the Arizona bar requires disqualification. On that issue, California law is clear. Under the facts of this case, Mr. Marraccini has no standing to raise this argument. Okay, that's your opinion. Then there's because he is not a former client and had no confidential relationship with Mr. Marraccini, lacks standing to seek disqualification based on conflict of interest. Okay. Well, why I is there? Okay. On page 8 of his motion, Mr. Marraccini attempts to explain the legal standard. Okay. Disqualifying of counsel, citing various cases, Great Lake. Marraccini then argues courts should disqualify based on alleged hypothetical conflict of interest he has with Ms. Owens arising from the bar complaint Mr. Marraccini filed in Arizona. Why are you rewriting the same shit? If Marraccini's counsel had bothered to read... We read this already. Bothered to read. Generally, before the disqualification of an attorney is proper, complaining party must have... Okay. So now he says this other thing that says we reject the argument and the Code of Civil Procedure Action 128, Subdivision A5, permits a court to dispense with standing requirements when evaluating attorney disqualification motions. The state gives court authority to grant disqualification motions brought by a party who meets the standing requirements. Thus, a moving party must have standing. That is an invasion of a legally cognizable interest to disqualify an attorney. Okay, that's not on the other page. Let's see. Here, putting aside the fact no actual or even potential conflict exists, Mr. Marraccini clearly lacks standing to seek disqualification based on alleged conflict between Ms. Owens and her counsel, whether present or former. Although Mr. And we'll get to that page, but page 6 is almost identical to a previous page we read. I just don't know which page it is.
Marraccini seems to enjoy articulating his personal belief that the undersigned is acting unethically by violating certain rules of professional conduct. Pretty gratuitous ad hominem attacks are not the sort of legal cognizable interest that confers standing. The state bar rules of professional conduct govern attorney discipline, not standards for disqualification in the courts. Okay. It still can be taken into consideration for the judge. And if it was dismissed and they did nothing for it, then that would be, a point in your column, but that's not what happened. So it's a point in Marraccini's column. Beyond Great Lakes, other cases cited by Mr. Marraccini compel the same result, albeit for slightly different reasons. For instance, Mr. Marraccini also cites these, which oddly mentions Great Lakes, but then partially disagrees with it, stating no California case has held that only a client or former client may bring a disqualification motion. And if this is not a reason to bring one, and Omar brought it in good faith thinking that it does, he can't be punished for that. Upon closer inspection, Kennedy does not help Mr. Marraccini's position. This is so because although Kennedy took a slightly broader view of when a non-client has standing to seek disqualification, it is affirmed that the rule that a moving party must have some sort of special relationship or interest with the opposing lawyer before disqualification can be sought. In Kennedy, that special relationship existed because the lawyer was disqualified from representing his own son. in a custody dispute based on a motion filed by the other parent. The other parent previously worked for Mr. Eldridge, who was um, somebody. Her mother consulted with Mr. Eldridge regarding her, Kayla, previous divorce, and Mr. Eldridge's firm previously represented Kayla's father. As a result of the foregoing, attorney Richard has access to Kayla's confidential information. In other words, the court found although Mr. Eldridge had not directly represented Kayla himself, his firm and previous represented Kayla's father and had sufficient other indirect contact with her family members such that the firm obtained confidential information about her. Well, you would be trying to seek personal information for your own fight against the state bar. But I gave the scenario, I don't remember because I'm recording this on 2 separate days. I don't remember if I gave the instance in this video, I believe it is, about, a doctor or a lawyer representing somebody else and then becoming your lawyer and all that. I think it was this one, but continuing on, he says, the Court of Appeals held that highly unique circumstances warranted disqualification of Mr. Eldridge. The trial court could reasonably find there was a significant danger that, as a result of its prior involvement in her father's divorce case, the Eldridge firm acquired relevant confidential information about Kayla to which it otherwise would not have had access to. Given these narrow and unusual facts, other courts have dismissed Kennedy as an outlier with only limited application. Explaining Kennedy is an outlier due to the unique factual circumstances it addressed and is not determinative here. While we do not believe a non-client can never establish standing, case law consistently denies standing to a non-client. Here, Mr. Marraccini lacks standing because he does not allege anything remotely close to the unique facts of Kennedy. He does not allege any prior attorney-client or other relationship with the undersigned, either as to himself or any of his close family members. Again, the key issue in Kennedy was the fact, not present here, the disqualification lawyer's firm previously represented the moving party's father, and the moving party declared that, as a result, the Eldridge firm did acquire access to her confidential information by virtue of that representation. Mr. Marraccini is not a former client. He does not claim, and certainly does not show, the undersigned ever acquired this confidential information by representing his father or any other family member. Well, no shit. Instead, Mr. Marraccini simply wants to disqualify the undersigned for reasons of personal dislike and because he perceives, incorrectly, some nefarious personal motives are involved. But if you said there were nefarious notions or motives, personal motives, then there's a reason to think that because you said that. If you did. I don't know if you actually did or not, but it's been alleged that you have. But if that was the correct standard, Mr. Serrato would equally be subject to disqualification for the same reason, because Ms. Owens and the undersigned believe Mr. Serrato is not pursuing this matter to advance Mr. Marraccini's best interest. Instead, Ms. Owens and the undersigned believe Mr. Serrato is acting primarily, if not exclusively, for his own self-interest. What is Serrato getting out of this? Nothing. He might be getting paid, but he's not making content about it, so he's not benefiting from it. Because Serrato doesn't benefit from somebody else making content about him. He has no benefit, especially if it's a monetized channel. He's not getting a kickback of any of that monetization. So I would like to see what the reason is. So Mr. Serrato hopes to use this case to help gain. What does he hope to gain? He hopes to gain subscribers for his YouTube channel. Why is he going? Where does he want subscribers for his YouTube channel? Because nobody is going to get any information from him about this case by subscribing to his YouTube. So any lawyer that has any social media platforms, it's all about fame. Okay? And to generate new content for his friends to share on their YouTube channels, as has already occurred. He is not doing this for content for anybody. He is filing things in a court. He's keeping it in the court himself. And we have to wait till a docket is uploading this stuff. We don't get it before then. We get it when it's made public by the court. So this is just a case. You seriously need to do some research. Either way, the law is clear. Personal hatred for an opponent or opposing counsel does not confer standing to seek disqualification. That single fact is dispositive as to the conflict agreement. Furthermore, no conflict, either actual or potential, exists between Ms. Owens and counsel. Although it is certainly possible that the State Bar of Arizona might someday pursue future discipline relating to Mr. Marraccini's complaint, that has not happened yet. Such a highly speculative and tactical interest does not meet the standing requirements. Great Lakes. And even if it did occur, this would still not create a conflict sufficient to warrant disqualification because both Ms. Owens and the undersigned each hold exactly the same views. They believe Mr. Marraccini violated this court's order and that he should face consequences as a result, and that Mr. Marraccini's complaint to the Arizona Bar is frivolous. Well, the Arizona Bar didn't think it was frivolous, because if they thought it was frivolous, they would not have found probable cause. And they did. So the State Bar of Arizona disagrees with you, David. And it's not because y'all's interests are not aligned. It is because you are too close to this case. You've gotten yourself too personally involved with your client that you cannot be objective anymore. You have never been objective about this case or any case regarding Laura. The bottom line is this court need not concern itself with any alleged conflict between Mr. Owens and the undersigned. I think it's supposed to be Miss Owens, but okay. Indeed, because the attorney-client relationship was voluntarily terminated, there is no basis for Mr. Marraccini to argue a current conflict exists, and thus disqualification could not be justified on this basis. The advocate witness rule does not apply because the undersigned no longer represents Miss Owens. Why are you making phone calls in your role as an attorney to come to agreements and settles? Why are you trying to settle things and stipulate to certain things? It's because you're acting as her attorney. You've admitted to it. On page 9 of his motion, Mr. Marraccini argues a lawyer may not serve as both an advocate and a witness on material issue at trial, absent narrow exceptions, emphasis added. The argument misstates the law. In California, a lawyer can always act as both advocate and a trial witness if a lawyer's testimony relates to the uncontested issue or matter, but it is a contested issue. 3, the lawyer has obtained informed written consent from the client. Wonder what number 2 is and why you're not including it. Here, based on discussions with Mr. Serrato that took place days before he moved to disqualify, the undersigned made the decision to act as both an advocate and a witness. The fact was communicated to Mr. Serrato in writing on August 22nd, 2025. several days before the disqualification motion was filed. Because the undersigned will not be acting in a dual role at trial, Rule 3.7 simply does not apply here. Nevertheless, if the undersigned were to assume a dual role of advocate and witness, that would be permitted under Rule 3.7a1 and 3.7a3. As to the first point, the only issue that undersigned plans to testify about are factual matters which are or should be uncontested. For instance, the testimony of the undersigned was already set forth in a declaration submitted by Miss Owens, in connection with her original request to renew the DVRO. As explained in that declaration, the undersigned will, if needed, testify regarding events which are or should be completely uncontested. Okay, let's look at these uncontested matters. In June 2024, Mr. Marraccini appeared in Phoenix, Arizona, outside the Maricopa County Superior Court and came with less than 300 feet from Miss Owens. Okay. Mr. Marraccini later sat as a spectator in the gallery of the courtroom, approximately 20 to 40 feet away from Miss Owens for a period of more than an hour. All right. Mr. Marraccini initially been disclosed a potential trial witness, but the party who disclosed him failed to comply with the requirements. No, they didn't. That's your opinion. Nobody else sees it that way, which states each party must disclose the names, addresses, and the telephone numbers of any witness whom the disclosing party expects to call at trial, along with a statement fairly describing the substance of each witness's expected testimony. Well, I think him writing you and telling you what he's going to be talking about, Marraccini did that himself to you, and Woodnick said some things. To determine whether Mr. Marraccini was planning to appear at the trial, the undersigned talked to the contacted person listed for Mr. Marraccini, his former counsel in this matter, Randy Sue Pollock. Following that discussion, Ms. Pollock sent an email verifying Mr. Marraccini was not going to testify in Arizona. Well, at that time period, he wasn't. But you know what I don't see in any of this is the intent to do something to Laura. There's no intent here. He got brought into this case. Shortly after Ms. Pollock stated Mr. Marraccini would not be testifying, new information was disclosed by the respondent, Clayton Eckerd, which included text messages allegedly exchanged between Mr. Marraccini and Ms. Owens in 2016 to 2017. These text messages would have required Mr. Marraccini's authentication to be admissible in evidence. That determined whether Ms. Pollock's position had changed. A phone call took place on May 6, 2024, between Ms. Pollock and the undersigned. During that call, the undersigned informed Ms. Pollock that if Marraccini intended to appear as a trial witness in Arizona, that was fine as long as he complied with the disclosure requirements imposed by the Arizona law, which he did according to the judge. In response, Ms. Pollock stated Mr. Marraccini was not willing to cooperate with any investigation by the undersigned. Yeah, because you're not supposed to be doing an investigation, in my opinion. Maybe you are. And that instead, Mr. Marraccini intended to simply appear in Arizona as a non-subpoenaed spectator. Well, he wasn't a non-subpoenaed spectator, so in response to that threat, the undersigned sent an email to Ms. Pollock on May 6, 2024, that said, in light of that response, I want to make two things clear. One, if Mr. Marraccini intends to testify at trial, then I have the absolute right to know this, and I have the right to interview him. In family law, not really. I don't think. I could be wrong. I'm not a lawyer. The interview can be done informally in a phone call, or it can be done formally in a deposition. Yeah, I would want a deposition in front of a judge because I am not. And you know who could attend that deposition? Laura. And she would have too. I guarantee it. Either way, refusing to cooperate is not an available option if Mr. Marraccini wants to participate as a trial witness. On the phone, you suggested Mr. Marraccini may just show up at trial rather than participating as a subpoenaed witness, i.e., he would simply choose to be there as a spectator or as a non-subpoenaed witness. If that is the plan, I need to be clear about our position. If Mr. Marraccini shows up as either a spectator or a non-subpoenaed witness, Laura will ask Phoenix police to have Mr. Marraccini immediately arrested for violating the restraining order issued against him. Except that's not what happened. In short, I agree Mr. Marraccini can testify at trial without fear of arrest. Apparently not, provided he complies with the rules of procedure. That means, among other things, I have the right to interview him and take his deposition if necessary. If Mr. Marraccini does not want to comply with procedural rules, that's 100% okay. I am more than happy if he wants to stay home, assuming he hasn't been lawfully summoned. But if he comes within 100 yards of Laura without being complied to appear by a valid subpoena, then he will risk arrest and prosecution for violating the restraining order. Ms. Pollock never responded to this May 6th email. On the morning of June 10th, 2024, Mr. Marraccini violated the proximity restrictions of this court's DVRO outside the Phoenix courthouse. Federal law, the Violence Against Women's Act, provides full faith credit. All right, let's see here. Any protection order issued that is consistent with subsection B of this section by the court of one state, Indian tribe or territory, the issuing state, Indian tribe or territory shall be accorded full faith and credit by the court of another state, Indian tribe or territory, the enforcing state, Indian tribe or territory, and enforced by the court and law enforcement personnel of the other state, Indian government or territory, as if the order was enforced by that state or tribe. Emphasis added. Arizona law, ARS 133602V, is invicta, a valid protection order that is related to domestic or family violence and that is issued by a court in another state, a court of a United States territory or tribunal court shall be accorded full faith and credit and shall be enforced as if it were issued in the state for as long as the order is effective in the issuing jurisdiction, emphasis added. Arizona Rules of Protective Order Procedure Rule 28 provides A. Effectiveness of conflicting orders. When two parties have obtained conflicting protective orders, both orders must be given full force and effect, regardless of whether the orders were issued by the courts or limited or general jurisdiction, emphasis added. As these points show, substantially every detail of undersigned's expected testimony is or should be uncontested. There is no dispute Mr. Marraccini traveled from California to Arizona. There is no dispute on June 10, 2024, he appeared in Arizona less than 300 feet away from Ms. Owens. The only remaining issue is purely a question of law. Does Mr. Marraccini have some lawful defense for his conduct in this situation where Mr. Marraccini claimed to have been served with the Arizona subpoena, which is legally unenforceable in the California state? Does that mean he had the right to travel to Arizona and violate this court's DVRO by approaching Miss Owens in the parking lot? He did not approach her. He might have walked past there to get to the courthouse, but he did not approach her. So stop lying. He didn't talk to her, nothing. Put another way, does an Arizona trial subpoena issued by a lawyer, not a judge, override the DVRO from this court, or was Mr. Marraccini required to comply with both? The subpoena was issued by a lawyer, not a judge. Did the judge sign off on the subpoena? I'm gonna have to look at that. But the judge agreed to the subpoena, so I don't know. Let me look at that. Let me come back to that part. The terms of the DVRO by staying at least 300 feet from Miss Owens and with the Arizona subpoena. Okay. So a witness in a family law case is not legally obligated to speak with opposing counsel. They can request, informally request, hey, can we talk to you? And that witness can say no. But had Gingras subpoenaed him himself or had a court order to say that he had to from the judge or subpoenaed him for a depo, then it would be different. But none of that happened. And then lawyers can write subpoenas without the court's approval. If they're acting as, they're acting as a representation of the court. There's different rules in different jurisdictions and different courts, and they have to, adhere to those specific rules and procedures. If the judge didn't agree with it, she could have struck it, and said, no, like, your subpoena is not going to be okay. But because they're kind of acting, and basically by the lawyers issuing the subpoenas, it saves the judge time, and so it's for efficiency, is what I've read. But again, I'm not a lawyer, so I don't know all the ins and outs. Let's continue on. In this motion, Mr. Marraccini boldly asserts it's doubtful that David Gingras, who has been practicing for nearly roughly 25 years, has a profound misunderstanding of the law, that he reasonably believes Marraccini violated the DVRO by complying with a valid issued subpoena, quote unquote, or quote, he said. He said that's motion, but Marraccini cites no legal authority of any kind to support his argument. That subpoena issued by a lawyer, not a judge, somehow overrides a valid domestic violence restraining order, thus permitting Marraccini to pretend the DVRO no longer exists. Mr. Marraccini's argument further appears to directly conflict with both federal law and Arizona criminal law, both which require out-of-state court orders to be enforced, which did not occur here. In sum, substantially all factual issues the undersigned plans to testify about are or should be undisputed. Thus, even without client consent, Rule 3.7A1 would permit such testimony even if undersigned was also acting as a trial advocate. And, of course, Miss Owens has given her informed written consent. The fact alone defeats any argument Mr. Marraccini could otherwise make as to Rule 3.7. On that issue, the court task is easy. It should simply adopt the same logic other California courts have used when ruling on this question. These remarks should sound familiar. Before the court, a motion seeking to deprive a party of its chosen counsel. These qualification motions come with a high risk of improper motivation, such as eliminating formidable opponents, disrupting or harassing the adversary, increasing litigation costs, or distracting from the important issue. State bar associations have responded to this risk in various ways, including deviating from the ABA model rules to further protect parties against gamemanship. Under California rules, parties may avoid the disqualification of their lawyers by consenting to their lawyers serving as a witness. When, as here, such consent is given, the analysis should end. Okay. And maybe if that's all it was, it really might not be a problem. But that's not what it's all about. As the district judge explained, Vertucci, older California decisions cited the now abrogated professional conduct rule 2111 to reach conclusions which are no longer valid, particularly since the California rules of professional conduct were substantially amended in 2018. Well, I'm glad you've read those. I'm glad you're familiar with the professional conduct rules. You will need that. Specifically, in analyzing the dispositive impact client consent has the issue of disqualification for a lawyer seeking to testify at trial. The Vertucci court rejected older cases such as Lyle v. Superior Court, which is cited on page 12 of Mr. Marraccini's motion, cited Comden v. Superior Court on page 13 of the motion, because they were based on prior versions of ethical rules which contain no exception for client content or consent. Since the rules of professional conduct were amended in 2017, effective November 1st, 2018, see footnote 2, which he gives a link for, cases like Lyle and Comden are likely no longer valid law under the current version of Rule 3.7, allowing dual roles as long as the client has given consent. Informed consent ends the inquiry. I don't think she has been fully informed. But that's just me. I don't know that I think this needs a colloquy. If in fact the judge is like, no, I'm not going to disqualify him, but I am going to do a colloquy of Miss Owens about this, understanding the pros and cons, or the cons of this happening, and that she is making a knowing decision. And then the judge can go from there. Finally, Mr. Marraccini cites cases such as Geiger versus Blue Rider Finance. For the principal, courts retain discretion to disqualify an attorney under Rule 3.7, even with client consent. But in that one, the Court of Appeal reversed the trial court's disqualification order, finding was improperly based on overreaching statements of policy and conclusory allegations by the party seeking disqualifications. Here, all other issues aside, Mr. Marraccini offers literally nothing but statements of policy and conclusory allegations of prejudice. Neither is sufficient. And maybe he's right about that. Gingras could be right about some of these things. But it is up to the judge. And all Omar was asking was, hey, can you disqualify him? We would really like him to be disqualified. And the judge can say yes, or the judge can say no. And then the case will go on, with or without Gingras attached to it, as a lawyer. That's it. Conclusion. Mr. Marraccini's motion to disqualify is groundless. There was no basis to bring the motion even before the attorney-client relationship between undersigned counsel and Miss Owens was terminated, which happened before the motion was filed. But after the relationship ended and after Mr. Serrato was informed of the fact in writing, again before the motion was filed, the motion crossed the line from groundless to sanctionable. I don't think this is sanctionable, but and you know, David, if you just kept it to this, you would be fine. But when you go in there with your vendetta and craziness about YouTube conspiracy theories that you have that are not valid, they have no basis in reality, that's where you lose everybody. But if you just give us these sites and things like that and these rules, we can look them up for ourselves and everything else. But it's when you're going
down that crazy train that you lose people. Be the guy just citing case law in your motions and making it about the law. That's all you need to be doing. You are doing too much with that other shit. For the reasons stated above, the motion to disqualify should be denied. In addition, for the reasons stated in concurrently filed motions for sanctions, this court should find Mr. Serrato violated CCP 128.5 by bringing the motion in bad faith, by intentionally lying to misleading the court. I don't think he did that. And by using a tactic which was frivolous and intended solely to harass and cause unnecessary delay. No, you are causing unnecessary delay. You could have just ignored this and said, well, I'm not on that case, so I don't even care if he tries to disqualify me. Like, don't give a shit about it. But you care so much. You wanted to start a whole shit ton of crap. And so he served it to the correct people, and then he has proof of service, and he emailed these, which he does most of the time. He emails them. But earlier, in another filing, when we went over, he sent it by U.S. mail, which I don't understand. So he signs it under the perjury laws of the state of Arizona that the foregoing is true and correct. And he wrote this on October 7th, 2025 in Phoenix, Arizona, and signed his name. So that is this motion. But get ready for the next video, because David has become deranged. Bye.